डिजाइन है ठीक है हर ऑफेंस मैं भी किसी पे गोली मार दूं इस कमरे में everybody will be scared right but I don't have the intention to promote ISIS or anything right so then it's not terrorism.
Is the evidence coming from like the organization accepting the responsibility?
That is definitely one form of evidence. There's also a lot of intelligence intercepts that you get for it. Then you can find hard evidence. If I was a suicide bomber or something, you can go back to my house, you can look at the literature that I was looking at, what websites was I going through, who have I been calling, if these people are in our database, then you know that they're linked to terrorism.
And especially you accept the responsibility, that's not a very credible way.
There are multiple organizations who accept.
मैं किसी को मार दूँ, उन्होंने अपनी आइडियोलॉजी स्प्रेड करनी है, वो कहते हैं कि हमारी बंदे ने किया है, और उनका पर्पस ज़्यादा अच्छी तरीके से अचीव हो जाएगा, हर सिविल ऑफेंस, हर क्रिमिनल ऑफेंस को करके अपना.
Absolutely, absolutely, that's exactly how it is. Okay, so. This is just technicalities. There's a third schedule which brings in quite a bit of other things as well. This is the actual definition. Okay, so it has these three parts. This makes a reference to another part. Okay, so there has to be an action. The action is in the next part, and we'll go there. But in addition to the action, there has to be the use or threat is designed to coerce or intimidate overall the government, or a section of the community, or a sect, or the public, or a foreign government, or a population, or an international organization, or create a sense of fear or insecurity. Okay, so this is one part. The second is, यहाँ UK में and था, हमने यहाँ पे or डाल दिया, because we thought it would be more difficult for a prosecutor to prove both things. So to make it easier to prosecute, we said that these are disjunctive. They don't have to be together. इनमें से एक मिल गया तो that's enough. The second is the use of threat is made for the purpose of advancing a religious, sectarian, or ethnic cause, or intimidating the social sector. This and this. I've done a lot of analysis of this particular thing. There's a lot that can be said in chapter 4 and here, and there's a lot of problems here. These two are technically the mental element of it, right? Okay, you have to have the intention or the design or वो आपके दिमाग में होता है. It's not in the act. But strangely, so the user made for the purpose of this, killing business community or attacking. Attacking is not a mental thing. Attacking is a physical thing.
Right.
So suddenly in the mental thing, they've come convolutedly put in attacking the civilians, including damaging. Damaging is not a mental thing. It's a physical thing. So they have confused the actus rea and the mens rea very significantly.
Yes.
And what that means is, you don't require any mens rea there. Because if the mens rea is also an action element, you need the action and the action. That's basically what we're saying. Okay. So that's why it becomes really scary on the ground. Anyway, so let's move on. Now these are the different actions. So this mixed with some of that mental element will make you a terrorist in Pakistan. Involves the causing of death, grievous violence against a person, grievous bodily harm to a person, grievous damage to property, including government. So yeah, property, government premises is also property. You don't have to put in this superfluous institutions right here. Anything hostage taking, hijacking, kidnapping for ransom, explosives by any device, incites hatred, takes the law into his own hand. This is just some of them. These aren't all of them, obviously. Terrorizes individuals, communities, etc. So as it stands today, we have 54 anti-terrorism courts. Roughly 54, maybe added a few. There's a fast-track procedure. The Supreme Court guidelines in 11% are not being followed. It's simply impossible. जो law में था कि आप within 7 days trial कर लेंगे, वो नहीं हो सकता. It takes a good 2-3 years sometimes to do ATC trials. No bail for offences under the ATF for which punishment exceeds 3 years. There's special provisions for witness protection, and these courts have specialized prosecutors as well. So there's a specialized cadre of prosecutors that deals with them. Training levels and those, I mean, leave much to be desired at times, but could be. This is interesting. This is something that they've added recently. Convictions on the basis of electronic or forensic evidence. A person accused of an offence under this Act may be convicted on the basis of electronic forensic evidence, or such other evidence that may become available because of modern devices or techniques. Why is this important? What is the primary form of evidence in Pakistan?
Shahadat.
Ocular evidence, eyewitness evidence. Somebody saw it. That's why it was so important to include witness protection measures, and this was again one of our amendments to it that we suggested. Because the weakest link is the witness. He's the one who जिसके ऊपर आप pressure डाल सकते हैं, आप हमारे family member को मार देंगे, तुम्हें ये कर देंगे, all of that. Okay? He's the weakest link. So what they said is, we'll try to protect him as well, but we'll also try to shift the burden from a witness to forensic evidence
techniques,
which doesn't lie.
Right.
I mean, there can be errors in it, but it doesn't lie. Right? So these are some things which if you read our case for change, our report, this is what we try to do. We said shift the burden from the witness. Because if everything is on the witness and on your testimony, you're not going to get convicted. And that's why the conviction rate was really low. And we'll go through that in a bit. Preventive detention, it's you basically have every 3 months. So for 3-month period, you can detain a person for a certain amount of time.
And then you get request for extension.
Yeah, and Article 10 of the Constitution applies to this. So there's only so much you can do. You can only limit detain a person for up to 2 years or 8 months within that 2-year period or so. Okay? Or 12 months. So 8 saal se zyada aap nahi kar sakte. You can ban organizations. Then the best place for any person to be is on the 4th schedule of the Anti-Terrorism Act. If you're on the 4th schedule of the ATA, your life is hell. If there is any place where there are human beings, basically women and children, you cannot go there. So if you're on this, you're suspected terrorist, so they'll put you on the schedule, then your freedom to move, your freedom of movement is severely curtailed.
It's like Pakistan.
You can't go, bus अड्डे नहीं जा सकते, airport नहीं जा सकते, school के नज़दीक नहीं जा सकते, parks, cinemas तक यार, cinema भी नहीं जा सकते, ठीक है? None of these things, and the only problem is, आपने कर तो दिया, you put it down in the law. Who's going to enforce this? If I'm on the 4th schedule, is there going to be a policeman who follows me everywhere? No. Will policemen have a picture of me in their wallets saying, "Abhi ye aayega to main isko pakadunga"? No, obviously, right? So this is unenforceable. It's nice to have it there, but
हो सकता है enforce?
कैसे enforce करोगे?
That's
the thing. The problem जो पाकिस्तान में आता है सबसे ज़्यादा is money. ठीक है? Ankle braces cost money. And it requires training. Who's going to do that?
Metro Council did that, maybe ask.
Metro Council.
This is more.
If only people. This is a high priority. And exactly, we're neglecting it.
But इतना भी महंगा नहीं होता है.
नहीं होता man. If you want to implement a program, you can have Pakistanis develop it. क्या यार?
लोगों के develop आराम से हो सकते हैं.
लोगों के phone अगर track हो सकते हैं, ये track नहीं हो सकता.
आराम से हो सकते हैं. Ankle bracelet.
Ankle bracelet tracker लग जाता है basically. So we know whatever the person.
It's live reporting of the person.
Exactly.
Nobody needs to be paying attention to live data coming. The system will
automatically
itself.
Outside of your house, there's a perimeter. You can only go say 100 meters outside your house. So if you leave that automatically, it starts beeping. The police come in to that location. Okay, so let's quickly look at some statistics. These are a little old. These were presented in the Supreme Court by the Attorney General, so these are as authentic as you can get. Total number of cases in June 2014. 17,596. So anyway, number of cases under trial. Okay, this is how many were done, completed. This is what are remaining under trial. Now from the 7,565 cases, how many were acquitted? 5,841. And only this many convictions. That's a 77% acquittal rate. 23% is the national average. 23% conviction rate in a country with this level of terrorism.
And even then it is bloated numbers.
Probably bloated. Now let's break this down by province, and that's what will really scare you. 23% चलो ठीक है यार पाकिस्तान में हो. पंजाब में क्या rate है percentage wise? Because average निकलती है ना. So let's look at average क्या बनती है. Punjab has the highest number of cases, 27% conviction rate. Sindh 28% conviction rate. Balochistan had 58 cases. Really, it's a statistical anomaly, but they had a 88% conviction rate. They had 58 cases total.
Absolute number.
Absolute. And they started much later as well. KPK, which is the province hardest hit by terrorism. Do you know what their conviction rate was in June 2014? 7%. 7%.
उसके लिंक्स तो पीछे किसी ऑर्गेनाइजेशन से हैं, तो आज
ideal तो वही situation है, you can get there.
Terrorism force में ऐसी कोई example है military force में तो नहीं चाहिए?
Absolutely, like, I mean, if you are involved in a terrorist organization, that itself is an offense. But if you are involved in a terrorist organization and you are masterminding plans, तो conspiracy to commit, आपने खुद ना भी किया, आपने किसी छोटे को भेजा, ठीक है? तो you are involved in the conspiracy to create to commit an offense. So you can be convicted in that situation as well. Or you created and abetted him, आपने पैसे provide किए, you finance terrorism. All of these things they can catch them, but उसकी evidence here. How will you prove that I, the boss, talked to this person here and told them कि आप जाकर वहाँ attack करें? इस बंदे नहीं बताना है ना, सिर्फ हम दोनों ने सुना है. या अगर मेरा फोन पड़ा है, मैंने फोन पे बात की है, तो वो recording आ जाए. But that's intelligence-based evidence. Now the problem with intelligence-based evidence is that you require in Pakistan a warrant for it, and you require this anywhere. If you want to tap someone's phone, there is a law, again, which was developed by our office, Mr. Sufi and the rest. It's called the Investigation for Fair Trial Act. It's called the Investigation for Fair Trial Act. So this is your intelligence and surveillance and all of these tools. So basically, if you require to tap someone's phone or to plant a bug or a camera in their house or something like that, you can get a warrant from a high court judge. There's a problem in this. These are usually emergency situations. Okay? You need to get a warrant immediately. So if you could quickly just go to a judge and get it, that would be perfectly fine, right? But the problem is that because Parliament was scared that people would, or the intelligence agencies or the police would start getting warrants against them, they decided to say, no. First you will have to get, if I'm the investigator, I have to go to my departmental head, get his authority, and by getting his authority, he will then have to send a letter to the Minister of Interior, who will then say okay, and then you can go to a High Court judge. The Minister, so there are three layers. My departmental head, the Minister of Interior, and then the High Court judge. तीनों scrutiny करेंगे, how long will this take? Right. So या तो चले आप ये कर लें कि long-term investigations के लिए you can use this. But immediate presentations immediate investigations के लिए you should have an emergency provision where you can just get, say, the departmental head gives authorization, you go straight to the judge. या वो भी ना हो, the officer can directly go to a judge and seek a warrant for interception. So it's extremely important that these things are looked into, okay? Because terrorism is fought in the field of intelligence. Please.
There was a case. अमेरिकन आई थिंक वो केस था, उसके अंदर ये कि जो पुलिस ने ना बट लगाया था और वो बंदा जो था वो नारकोटिक्स और इस तरह के इलीगल काम करता था और बिना उसे बताया उन्होंने लगाया था और जब वो उस इंफॉर्मेशन को जब वो कोर्ट में लेकर गए थे तो उन कोर्ट ने रिजेक्ट कर दिया था और उसे अक्विट कर दिया था क्योंकि उन्होंने ये कहा था कि आपने उसकी राइट ऑफ प्राइवेसी को रोकी है.
Exactly, absolutely. That evidence can come here inadmissible. So one of the biggest issues we have right now is making intelligence evidence admissible, because it comes back to this debate on rights versus security. I don't mind somebody reading my emails as long as they don't make me a missing person. If that's the debate, right? If that's the thing we're coming to. As long as I'm not killed extrajudicially, I don't care if somebody reads my message. I'm the most boring person in the world. Okay? So, this situation, this is the debate. When it really comes down, theoretical discussion nahi anymore. This is the rubber meets the road, real life situation. How much do you value your